Hello everyone. So this is going to be a video about the history of English law and the sources of English law. So I hope to give you a very brief synopsis of the law of England and Wales and tell you a little bit about how the English legal system evolved. And then you'll learn some of the terms of art which are used in English law and introduce you to a few of the core concepts. And then you'll know a little bit about how law and the courts function. So anyway, it developed over many centuries. There were the Anglo-Saxons who were in it, came to England in the 5th century AD. Obviously, there were ancient Romans before that. We don't really know about the ancient Britons beforehand because they had no form of writing. We only know about them secondhand from what the Romans wrote about them. Anyway, so Anglo-Saxon traditions with the Norman legal traditions grafted on. Common law developed. Obviously, there was Roman law on the continent, confusingly sometimes called civil law. There's always been a dialogue between Roman law and civil law, somewhat converged with the formation of the European Economic Community, which then called itself the European Union. Obviously, since Brexit might diverge a little bit. So you should also know a bit about the court structure as well. So before 1066, there were the Anglo-Saxons in England, and they had juries, for example, but they believed a juror must know those involved in the case. Therefore, you knew their reputation, they're likely to be telling the truth or not. And these days, jurors must not personally know the defendant or the complainant. They might know who the person is, if it's a famous person, but not know him on a personal level, have met him. So it can't be a friend or an enemy. So after 1066, well, as I say, the Normans changed things. And then from the late 15th century began to change a lot more, and the church courts really scarcely existed except for strictly ecclesiastical matters concerning the clergy. And it was more centralised under Henry VII from 1485, the Court of the Star Chamber and so forth, setting up justices of the peace, or magistrates, these judges who deal with low-level criminal matters. And there are a lot more reforms after 1832 and the Judicature Acts. There used to be separate courts of equity and courts of law, but these were amalgamated in the late 19th century. So you go back prior to 1066, obviously England wasn't even one kingdom, several different countries. Northumbria in northeastern England, which stretched well into Scotland. East Anglia, Essex, Kent, Sussex, Wessex, which is southwest England. Wales, even Cornwall, Devon and Dorset were considered part of Wales as well. Mercia, which is the West Midlands of England. Cumbria, which is northwest England. Deira, which is north central England. The Danes were in the eastern half of England for a couple of centuries. So the system wasn't uniform across the country. Each kingdom had its own laws, and they were near constantly at war against each other. So different courts. The smallest unit of government was 100, which was an area where 100 families lived. Now, a family, if it was the nuclear family, might well be 10 people, mother, father, and children. Of course, people had more children back then because infant mortality was so high. And that's why there's the children hundreds in Buckinghamshire. Or remember in Oxford, a little stone by the road said, "Here endeth Northgate 100." As in the area was, the city was subdivided into areas called hundreds. So every month, the 100 would meet the heads of 100 families. And there would be 100 men who had to be literate, because of course most people weren't. And they would function as a court for petty local matters. And England's divided into counties, 48 of them now. There'd be a shire court every quarter, as every quarter of a year. And it went right up to, obviously, a court in London for very serious matters. But travel was very slow. Fast way to travel was by horse. Most people didn't have a horse. And even then, bridges were often underwater due to flooding in winter. So roads were very muddy and so forth. It was perilous travelling. There were bands of robbers hiding out in the forest, and obviously most of the country was covered in forest at the time. So common law emerged, things which are justified by past practice, as opposed to actually passed by statute, a statute being a law passed by a legislature. So what were the important developments? Well, common law is a law common to all. That's why it's called that. So the king had various courts from 1066 onwards, the Court of Exchequer to do with financial matters, because they had like a checkerboard, black and white squares, and moving tokens from this square to that square to represent how money is moving between different parties. The Court of Common Pleas, the Court of the King's Bench, and there's still a King's Bench walk-in at one of the Inns of Court. There were assize courts, which were local courts at a county level as well, a bit like shire courts. So there was a writ system. As if you wanted something done, you had to get a special legal document called a writ. And this concerned actions about personalty, as in personal property, civil suits to do with realty, as in land. But there were difficulties which came along. The writ system was too cumbersome and slow, and if you didn't have quite the right documentation, you couldn't get what you needed. So the system began to stagnate. But there was also the Lord Chancellor. He was the head of the King's Writing Department, but all these top positions were held by clerics, so he's a priest. The King confessed to him, he was keeper of the King's conscience, and he persuaded the King to mitigate the harshness of the system of law by introducing equity to do with moral virtue. Now, Henry VII advanced that a lot. So the Lord Chancellor then became the highest judge in the country. He was also the equivalent of Prime Minister, but there was no Prime Minister as such. And he wasn't elected in any sense. There were no party politics, just appointed at the King's fiat. That was Lord Chancellor. Because Chancery is the writing department of the King, because the King would receive hundreds of letters a day to do with all sorts of matters. Now, the Lord Chancellor couldn't respond to all these letters himself, but he was in charge of a department of clerks to deal with these, responding and filing things and legal documents, and what was a decision in this court. Was a person found guilty or not guilty? If guilty, what was the punishment? Who won this civil suit? And if so, what was the award? What damages have been granted, and so forth. So equity developed, particularly from 1485, because writs was too inflexible, and so we couldn't have this whalebone corseted system. And that's the Chancellor then set up the Court of Chancery. That's why people can be wards of Chancery, as in if custody is awarded by a Court of Chancery, custody of a child. So the decision is supposed to be on the basis of fairness. Tinsley against Milligan, 1993, is a case of this. And the various equitable maxims like equity delights in equality, he who comes to equity must come with clean hands, and so forth. So D&C Builders against Rees, 1966, is a case of this. So law innovated, mortgages and equities of redemption were set up, trusts of land were set up in the Middle Ages to deal with people going away on crusade and leaving things in the hands of a trustee who would then sometimes take the property for himself, and legally it actually was his, it belonged to the trustee. So that had to be rectified. So we got trust land, about how land is actually be used, and obviously financial trusts. So various remedies were invented, such as granting injunctions, as in forbidding you from doing something, ordering specific performance that you must do something, rectification, rescission. We were able to get out of a contract, for example, because the other party's done something very badly wrong. So in the 17th century, there were two parallel court systems. There was the courts of law and the courts of equity. In the courts of law, we had the Court of Common Pleas. The common law courts, they used writs, damages or reward, remedy was by right. Whereas in the courts of equity, this included those courts of chancery. They used those equitable maxims, and they developed various equitable remedies. There was wide discretion for the judge. The Earl of Oxford's case, 1615, is a seminal case in equity. So after this, the two court systems began to learn from each other, and they somewhat converged till, as I say, they were merged in the 1860s. So then they finally had fusion. So the County Courts Act in 1846 reorganised the local courts. Some counties were tiny, like Rutland, some were gigantic, like Yorkshire. So the Common Law Procedure Act 1854 gave the power to grant equitable remedies. And those Judicature Act, it's 1873 to 75, created a single civil court system. So they were united. So over more recent decades, what's happened with the Crown Court Act 1971, the European Community Act 1972, whereby the United Kingdom acceded to the European Union on New Year's Day 1973. The Human Rights Act was passed in 1998 under Tony Blair's Labour government, and it took effect in 2000. The Constitutional Reform Act was passed in 2005, taking the Lord Chancellor out of the judiciary. and the Supreme Court Act in 2009, so that the Supreme Court is a separate building from Parliament across the Parliament Square, and the judges in the Supreme Court, that they're called Lord and Lady, they're not in the House of Lords. They've got no right to go there, speak or vote. Okay, so the court structure, well, there's civil and criminal divisions. Civil division, well, Smith against BBC is a key case of this. Remember, decisions they're made on the balance of probabilities. The civil courts include county courts and high courts. The High Court is subdivided into the Queen's Bench Division, Chancery and Family Division, each dealing with different issues. There's the Court of Appeal, which you can look at civil matters. Obviously, things can go up to the Supreme Court. Remember, prior to 2009, we're often saying House of Lords. We only mean the judges in the House of Lords, not all the peers. The criminal division, R against Smith, is a leading case. And remember, things have to be proved beyond reasonable doubt. There can be an unreasonable doubt. You can still convict somebody if you have a very slender doubt, but a penumbra of doubt will not be sufficient to acquit someone. So the criminal courts, Magistrates' Court is the lowest level. They're stipendiary magistrates who are paid, and the others who are just volunteers who sit in panels of 3 who are unpaid. Any respectable man or woman over 18 can do that without any legal training. Or it goes up to the Crown Court. There's the Court of Appeal, can hear criminal cases. Things can go to the Supreme Court. And remember, prior to 2009, that was the House of Lords. So where does law come from? Obviously, there's European Community Law. There was the Treaty of Rome, signed in 1957, though the United Kingdom didn't accede till later. The Lisbon Treaty, importantly, which granted Article 50, which gave all EU member states the express right to withdraw at any time. And obviously, the United Kingdom has availed itself of that right. So European Community Law can have direct effect in member states. The regulations were instantly applicable throughout the European Union. Just in case anybody tells you EU member states are independent, they're not. Because as soon as that is passed, then it is law in that member state, even if every single person in that country voted against that law. There's also more secondary regulations, such as directives, each member state having to reach a certain standard by a deadline, or decisions which are applicable on those to whom they are addressed. So there's the European Court of Justice, or as we're now encouraged to call it, the Court of Justice of the European Union, which sits at Luxembourg. So we often say ECJ, European Court of Justice, although strictly speaking we're going to use this more unwieldy format. And not to be confused with the European Court of Human Rights, which is in Strasbourg. The ECHR is not a European Union court, is a very common misconception. But the ECJ and the ECHR have a good working relationship and are constantly in communication with each other. And the ECJ says they even follow the jurisprudence of the ECHR. The European Court of Human Rights, of course, having one judge from all the signatory states, which is roughly 45, really every European country except Belarus, and including Turkey, in case you thought it wasn't European. And there's the European Convention on Human Rights, drafted in 1948, which they're all signatories of, and they all try to live up to, supposedly. So let's look at British legislation. We know that Acts of Parliaments, sometimes called statutes, not statutes, statutes. There's a third T in that. There's also delegated legislation. Statutory instruments are passed enabling local councils to make laws. There are bylaws, local laws, orders in council and so forth. And obviously they're the various devolved legislatures, the Welsh Parliament or Senedd, the Scottish Parliament, the Northern Ireland Assembly, the London Assembly, and so forth. So statutory interpretation is an important issue in common law. Smith against Hughes is a case about that. There's obviously the golden rule, the literal rule, and the mischief rule. Talk about that on another occasion. Precedent really matters. What was previously decided? Donoghue and Stevenson is a leading case here, 1932, about that snail in that bottle of ginger beer in Scotland. And this is a case where it's found that English law was exactly the same as Scots law. So Scots law is more Roman than English law, but the differences should not be overemphasised. So that is just a whistle-stop tour through the development of English law. Toodaloo.